Well, welcome everybody to this webinar on gender equal pay that we are hosting together with Pallas Attorneys at Law and Pihr, a software company, Swedish software company that provides a pay equity platform that we are working together with. My name is Ronald Borgt. I'm one of the two directors of APROM, and we are a specialized HR consultancy founded in 1991. Before handing the floor to Michelle, who will be our first speaker, I have a few introductory slides to share. Gender equal pay. Well, we had a quite an introduction by having the Nobel Prize for Economics awarded in this area. So it can't be coincidence that we are talking about this now. The agenda for today is a short welcome, and then Michelle will talk about the likely impact of the EU directive, and then Magnus will talk us through how to prepare for such legislation, as Sweden is ahead of us in this respect. And then we have time for questions, and we are aiming to end at 11 o'clock. Short introduction. The scales are still not balanced. In 2021, things looked slightly more brighter. The Central Bureau of Statistics in the Netherlands reported the decrease of the pay gap with 2 to 1 percentage points. But fresh facts from a study done by Nijrode and Intermediaire, you must have read about it a month ago, showed that the corrected overall difference, so the difference in which you compare apples with apples, so to speak, has risen from 5% in 2021, 2 years ago, to 7.4% now. It also showed that the salary increases were also not balanced, especially not in the lower education jobs. The difference was quite substantial. And on the secondary side, we see that the study showed that men have more often bonuses, a company car, and/or paid overtime. Although there was also news that women more often have a 13-month pay. Now I would like to give the microphone and the camera to Michelle Maaijen of Pallas Attorneys at Law, who will talk about the likely impact of the EU directive. Michelle, very welcome to this webinar.
Thank you, Ronald, and thank you for the introduction. I will go ahead and share my slides, so please be patient. Ronald, I'm getting the notification again that I'm not allowed to share the slides. Can you?
Yeah, apparently it doesn't use the settings from the test. Yeah.
Okay.
I corrected it. Yeah.
Yeah. Great. All right. So, good morning, everyone, and thank you for joining this webinar on the Equal Pay Directive. As Ronald already mentioned, I think the subject is getting a lot of media attention, which I think is necessary. And on the other hand, from now on, I think that this subject will also be getting more legal attention, as we now have a European directive which shows us what we need to prepare for, what companies need to prepare for in the next 3 years when this directive should be implemented in national law. And that's what I want to talk to you about today, to show you what exactly this directive entails, what companies should prepare for, what is coming, and I would like to end my presentation with some legal challenges I suspect will be coming up. So to start with this new pay transparency directive, the goal of the directive is to promote pay transparency and to employ effective enforcement measures, which eventually should drive a transformation in the ongoing pursuit of ensuring equal pay. which I think in itself is a very noble and good goal. The directive aims to achieve this goal by introducing measures to increase wage transparency, which among others means that there will be an obligation to report on a gender pay gap, the existence of a gender pay gap, an explanation if such a gap exists. And attached to that, there will also be enforcement mechanisms such as fines. And there are also measures that will increase the legal position of employees faced with unequal pay. I think important to know for companies, HR representatives, is to keep in mind that June 2026 is an important date, because by then all national countries should have implemented this directive in their national legislation. And although 2.5 years from now seems quite far away, there is actually a lot to be done still. And Magnus will also share that with you later. But I think it would be worth the while to start preparing for all the upcoming changes in a timely manner. And we will guide you through that today. From a Dutch perspective, our own Minister of Social Affairs, Labor Law, has mentioned that she will make it one of her personal goals to try and have this implemented sooner than June 2026, because she believes that this is an important topic that we should not wait too long with to start implementing. For now, of course, those are nice words to hear. We should wait and see if she will be able to achieve that. But at least in the Netherlands, there is at least the goal to implement this in our national legislation rather sooner than later. Then the scope of this new European directive is all employers within both the public and private sectors. It also extends to encompass both current employees, but also prospective applicants. And furthermore, organizations employing a workforce of more than 100 individuals are, among other things, obliged to disclose disparities in compensation between their female and male employees. So certain obligations will be applicable for all companies. Certain obligations will be applicable for companies with 100 individuals or more. But I will show you that when we continue. So one of the measures that the new directive provides is that the job applicants will have a better access to information, which means that in the job offer prior to the interview, the company must provide information regarding the initial salary or the compensation range associated with the advertised position. So companies are forced to already, insofar they are not already doing this, inform applicants about the salary that applies for the role that they would like to have. Furthermore, which is, I think, an interesting new obligation, is that employers are no longer allowed to inquire about candidates' previous salary. And I think that this is also one of the reasons why it is difficult to move away from the gender pay gap, because if women are already paid less and with their new job they are informed about their previous salary and the new employer bases their offer on that previous salary, they will never be able to move away from this pay gap, which is the reason why employers are no longer allowed to inquire about this previous salary. Furthermore, employers have to make sure that vacancies and job titles are gender neutral and that recruitment procedures are also conducted in a non-discriminatory manner, so as not to undermine the right to equal pay for equal work or work of equal value. So this is something at the beginning and is focused more on prospective new employees and not so much your current employees. Then another measure that the directive entails is that it provides for better access to information by making sure that employers have to give their employees, their current employees, easy access to the criteria used to determine salary and career development. And these criteria must also be objective and gender neutral. So by forcing employers to be more open about these criteria, it will be easier for employees to determine whether they are in a situation of unequal pay or not. Interesting is that the European directive leaves some room for all the national member states to decide if they want to exempt companies with 50 employees or less from this obligation. So it will be interesting to learn for the Netherlands if the Dutch legislator will make use of this possibility, or that they will go ahead and make sure that this obligation applies to all companies, irrelevant of the number of employees that they have. So we will have to wait and see how this develops. All right. Then the new Article 7 of the directive provides also for better access to information by giving employees the right to inquire with their employer about the average levels of remuneration broken down by gender for employees performing equal or equivalent work. So this does not give employees the right to ask for individual information about colleagues. So it's not like you can ask directly, okay, my colleague A or B, what is his or her salary? It must be based on an average level of remuneration broken down by gender and related to people performing the same work as you do. But this will give you more insight and will be able to compare yourself to the other colleagues working in the same role as you are. Another obligation, or actually it's more of a possibility, is that this request to have this information can also be made through employee representation or an equality body. I think everyone can imagine that it's not always easy for individual employees to make this request to their employer, which is why this directive provides the opportunity to make such a request by an employee representation body or an equality body. I think in the Netherlands that will relate to, for example, a works council, which can do such a request. Maybe also the labor unions. And we, of course, have our Dutch College voor de Rechten van de Mens, which is our equality body, which I think will also be then authorized to make these requests. Furthermore, employers must also let their employees know every year about this right to receive the information and the steps that they need to take to exercise this right. So there is an active information obligation for the employer to let employees know, hey, you can ask us about this, and if you want to, this is how you can do it. And I think that this is one of the main things to prepare for as an employer. I think you should prepare to get questions about your remuneration. But Magnus will also talk about this further along. If, as an employer, you get such a request, you will then be obligated to provide that information within 2 months, which also gives the reason why it's important to prepare for this, because if you still have to retract all this information after receiving such a request and do that within 2 months, that may become challenging. Another thing that the directive will make happen is that employees should not be prevented from disclosing their remuneration for the purpose of enforcing the principle of equal pay, actually means that if they want to enforce this via the court or another equality body, that they cannot be prevented from disclosing this information. At the moment, you see that this sometimes makes it difficult because of the fact that employees all have a confidentiality clause in their employment agreement, and employers happily refer to this confidentiality clause and say, well, this is not information that you can use or share. But in order to allow employees to better enforce their equal pay rights, they cannot be prevented from disclosing this information any longer. Employers can require that employees who have received this information, other than that relating to their own remuneration or remuneration level, use that information only to exercise the right to equal pay. So you cannot use the information you get as an employee for any other purpose, which I believe is fair and reasonable. So that was one of the measures which relate mostly to access to information, which is more by the initiative of the employee. Another one of the measures that will come is the reporting obligation. So that's more of an obligation for the employer. Article 9 of the directive provides for a reporting obligation on the gender pay gap. And the report must provide the following information. I've listed that here. It must provide information on the gender pay gap, the gender pay gap in complementary or variable components, the proportion of female and male workers, etc. This all seems like a lot of information to provide, but luckily we have companies such as Pihr that develop software that allows companies to easily provide all this information and make sure that they are compliant with their reporting obligation that will come. So here you see when companies should be prepared for this reporting obligation and how often they have to do this, which is based on the number of employees that are working in your organization. So you will see that companies with more than 250 employees are required to report this annually. Companies with 150 to 249 employees can do that every 3 years. The same is for 100 to 149 employees. They are also given a little bit more time to prepare for this reporting obligation because for them it will start by June 2031. And for now, companies with less than 100 employees, they can voluntarily provide this information. However, here is also another option for member states to have their own implementation, because a member state can oblige companies also with less than 100 employees to meet this reporting obligation. So again, this is also interesting to see how this will turn out in the Netherlands if our Dutch legislator will choose to apply this obligation for all companies, or that there will be an exception for the companies with less than 100 employees. At the moment, there is no indication yet what they will choose, so I'm not able to tell you yet where this will go, but I'm following this with a lot of interest to see where this goes for the Netherlands. So moving on with this reporting obligation, if the report that you provide indicates an unjustified gender pay gap of more than 5%, and you cannot justify this gender pay gap by objective gender neutral criteria, and you have not remedied such an unjustified difference within 6 months after you submit the report, then you have to take action as a company. Because then you are obligated to have a joint pay assessment conducted together with employee representatives. And that pay assessment will be carried out in order to identify, remedy, and prevent differences in pay between female and male workers that are not justified yet. So that means that if you come to the conclusion that there is a gender pay gap in your company and you want to prevent having to do this joint pay assessments, you should be able to justify, based on objective and gender neutral criteria, why this pay gap exists. If you are not able to do so, and you will have to follow this joint pay assessment, here you can see an overview of what should be carried out in this joint pay assessment. I will not go through all of them with you in detail, but it should include at least an analysis of the proportion of female and male workers, information on pay levels, on averages, the difference within those pay levels, the reasons for the differences, the measures that you will address to correct those differences, and an evaluation of the effectiveness of these measures. So a lot of explaining to do, so to say. So we talked about the information access for employees and the obligation for employers to report on the gender pay gap. Finally, I would like to talk about the remedies and enforcement that are included in this directive. There are a number of them. For example, member states must provide accessible court proceedings for the enforcement of equal pay. This includes cases where workers believe that they have been treated unfairly, and you should be having access to extend to those representing workers even after their employment ends. I dare to say that in the Netherlands, we have such an accessible court proceeding already. So I don't think that that will be a challenge for the Netherlands, at least when implementing this directive. What is important for employers to be aware of is that there will be a shift of the burden of proof to the employer in pay discrimination cases. So it will actually be up to the employer to provide proof that there is not a unequal pay situation going on. So this is a big change, of course, in the advantage of the employees, but definitely something for employers to be aware of, and that you really should be able to explain based on objective criteria that there is no, or at least a justified difference in the pay. Then another remedy is that the assessment of whether workers are in a comparative situation will not be limited to situations where female and male workers work for the same employer. So you can also make a comparison actually with people working in other companies. Member states also have to establish regulations for penalties that are effective, proportional, and discouraging for violations of equal pay. And the penalties should significantly discourage breaches of equal pay rights, and they should be determined according to national law. And finally, workers and their workers' representative must not be treated less favorably on the ground that they have exercised their rights relating to equal pay, which I think is something that for now we already have included in our national legislation, but will be more emphasized based on this directive. Then another one that is really important to talk about is that workers who have sustained damages as a result of an infringement or any right or obligation relating to this principle of equal pay have the right to claim and to obtain full compensation or reparation, which means that they should be placed in the situation in which they would have been not discriminated against on grounds of sex, or if there had been no infringement at all. Member states have to ensure that compensation includes the full payment of outstanding remuneration, as well as related bonuses or payments in any kind, compensation for loss of opportunity, etc. Especially for the Netherlands, this is interesting because at the moment in the Netherlands, we have a legislation that says that for back payment of salary, you can only claim that for 5 years. So a claim for back payment of salary wages is capped at 5 years. which means that in theory, if a Dutch employee would have been paid unequally for already 10 years, based on our own national legislation, they could only claim 5 years of back payment in wages, whereas this European directive does not put such a limit on the claim for compensation. So it will be interesting to see from a legal perspective how this will develop, and if that means that our own national cap at 5 years is no longer allowed given this new European directive, and therefore makes it possible to claim wages for a longer period of 5 years, or if our own national cap at 5 years will have an impact on this European directive, meaning that in the Netherlands at least, employees will not be able to claim that for more than 5 years. And how this will turn out is not clear yet. I hope that they will take this into consideration when implementing this European directive in national legislation. But if it would eventually mean that employees can claim salary for more than 5 years back, that will have a huge impact for Dutch employers. Finally, I wanted to quickly mention some legal challenges that I foresee with this European directive. I think one of the challenges will be to define criteria that you use to determine salary and career development, which have to be objective and gender neutral. For some companies, maybe this is already in place. For companies where this is not the situation, you will have to define these gender neutral and objective criteria. Another challenge, I think, will be the legal definition of equal or equivalent work, because we will have to start determining within companies what is considered equal or equivalent work, and how will you determine that for all the positions that are available within your company. Preparation will be a challenge, but Magnus will talk to you about that soon. Meeting the criteria of the reporting obligation. There is quite a list of all the information that you have to provide. So that is also something to prepare for, and make sure that you are able to come up with all these criteria once you have to. Also, the legal justification of a pay gap, if it is more than 5%. My estimation is that this will also be a challenge, because often this is related to things that happened in the past, which are a given at the moment. And sometimes it is not also possible to look back and see why decisions were made as they were made, and why this has existed. So sometimes there is no paper trail, so to say, to be found where you can explain this. And then how are you going to justify in retrospect if there is a pay gap larger than 5%? That may be a challenge for companies as well. Future claims for compensation or reparation, as I just explained, even if it's only capped at 5 years, this could still mean a pretty substantial financial compensation to be paid to employees. If there is no cap of 5 years, it may even be higher. The shift in burden of proof, which means that the employer must be really well prepared and have all their documentation in place to be able to show that there is no situation of unequal pay. And that may be challenging if, like I just mentioned before, this is something related to the past and there is no documentation to be found anymore. From an employment law perspective, this may be a challenge, because if you come to the conclusion that there is an unjustified pay gap, you might need to change your pay structure within the company, which could ultimately result in unilateral changes in terms of employment, which is not easily to achieve under Dutch law. That could also mean involvement from the Works Council, if you have one within your company, because a change in pay structure is something that you should involve the Works Council in. And these changes in pay structure and the unilateral change of terms of employment is also interesting because you have, as an employer, several options. You can choose to level up all your employees and make sure that everyone is at the same pay. But the question is, of course, also, can you also lower salary of employees? So rather leveling everyone up, can you also say, but this should be the level of pay that you are entitled to, but you're earning more, which is unjustified. Can you then lower the salary of employees to make sure that it becomes equal again? And can you do that with immediate effect? Or should you create some kind of a period where in small steps it will be brought back to the salary that they are entitled to? Another option could be to say, okay, we're not going to increase the salary of certain employees and freeze their salary until all the other employees have increased to the same level. But these are all changes in terms of employment that under Dutch law you should at least have the consent of the employees if you don't have sufficient reasons to do that unilaterally. And then finally, I think we all must expect an increase of court cases against employers who are not prepared or not able to justify their pay gap or are not willing to compensate employees for their damages and losses. So, yeah, I think a lot of legal challenges coming up. Reason why we are here today to talk to you about it and help you prepare. And that is what I wanted to share with you today.
Thank you very much, Michelle, for this explanation. It was a lot of clarification, and it certainly means that Dutch companies have there's something coming up that they have to prepare for, and that is exactly where Magnus will talk about now, because in Sweden this has already happened. So Magnus, I'll briefly show the introduce you through this slide. You are from Pihr,
Yes.
the software company that we are working together with in this respect, and I'm curious to hear your story, your experiences.
Sure. Morning, everyone. Thanks for joining the webinar. And thanks, Michelle, for that thorough legal review. As you can see, there's a lot of changes happening across the EU. If you are joining us from a multinational company, this will mean that you will have to potentially keep track of many different countries in the EU, since everyone will be implementing this separately from each other. It's not regulations, which means that you basically can have one legislation in the Netherlands, one in Belgium, one in Sweden, one in Germany, for instance. So it's going to put a lot of pressure, I think, on HR and compensation benefits to be able to keep up in terms of the regulatory. So I'm going to share a few slides on what you can do to prepare, start preparing now. So just get me there. So basically, Pihr, in short, just to mention a bit about us, we're a SaaS impact regulatory tech company. So what we offer the market is a highly efficient tool, SaaS application that will basically run all your pay equity audits, gender pay gap reporting, pay transparency reporting, etc. And we always tie our product to current legislation. So if you make a pay equity audit in Sweden, for instance, it's Swedish legislation. If you do it in the UK, it's gender pay gap reporting, and we also have an EU module now for the pay transparency. So basically, our recommendations to prepare. So if we look at the first one, which is pay transparency for job seekers, what you really need to be ready for is make sure that you are very comfortable with your current salary structure, because it is going to be on display. So whenever you are, to Michelle's point, whenever you recruit, you're going to have to give up either the salary range or the actual salary for the position, which means that you will have a lot of internal individuals that will get to see this. All right. So if you don't have salary ranges that you're comfortable with showing and sharing, you should really get to work and start producing them now. We know from other countries wherever you start publishing, there's transparency legislation across a few countries in the EU, but especially in US states like New York, California, etc. Whenever you start publishing salary ranges, it sort of gives you a lot of questions internally, right? Because you might see a salary range and you believe that it's your role and you might be paid less, and you're going to start asking questions and wonder about your own pay. To that point, if you're a business controller, you see an ad for the company you're working at. The ad says that you are supposed to earn, 52 to 6,000 euros a month, and you're only paid 4,500. You're probably going to go and ask HR. So you need to make sure that you're ready to answer all these salary-related questions that are now going to be legal to ask for any employee. And also a big one, make sure to inform managers across the organization that you will shortly start providing information on salary ranges. So if you have a sort of a normal salary process where you set salaries is sort of between HR and managers and the management of the company, not particularly share everything with your employees. Very shortly, the managers are going to be getting asked questions as well, based on their jobs and their salary ranges. And also make sure that all hiring managers really understands that they can no longer ask about a candidate's pay history. The reason why this is in the directive is actually, it's supposedly, according to research, and scientific research, the most it's the biggest one that has the biggest impact on a gender pay gap. So, and the reason why they bring this into the transparency directive is basically that research shows that a female, if a female is discriminated at her current job, she will, if she's asked about her current salary, she will not lie. She will be very honest, while males tend to have exaggerate their pay. So if she says that she has 5K a month, and the male will probably say 55 or even 6,000K a month. So if she gets hired on her own sort of salary history, the discrimination remains, and she'll bring that along for her whole career. So that's basically why it's in the directive. So it's a very good point and a very good action to actually start closing the pay gap. Number 2, right to information for employees. So basically, you need to ensure that you have up-to-date salary records, by all means, at all times, and that they are correct. Make sure that the salary ranges are up to date. If you don't have them, again, get to work, start producing them. And also secure that you have equal pay prior to the legislation. So you know that it can stand the test of any employees asking, because they will be asking. I think we can be pretty sure about that. And also we recommend that you use the system of index salaries. And that's basically so that you don't reveal your actual salary structure when it comes to individual pay, but rather a percentage. So a comp ratio on a percentage on how the individual fares compared to their peers. So the next one is the reporting on the gender pay gap. To Michelle's points, it looks to be a lot of publishing that needs to be done. So what you need to do to be ready, you basically have to think of this as an external one and then one internal one. So with the external one, we really don't have to guess what's going to happen. We have the UK that's been in the forefront of this. So their legislation came into effect in 2017, which meant by April 2018, all these different companies started publishing pay gaps, right? So the BBC, for one, has had a tremendous problems with this because, huge pay gaps. They've been claimed, a lot of claims. They've been in courts, and they basically lost a lot of equal pay claims. PwC has been on the front pages of UK media, that they happen to have the biggest, highest pay gap of all the big 4 firms. There's actually an interesting fact that female applicants for the big 4 companies in the UK are down by 30% for entry-level positions since the 4 firms started publishing their pay gaps. I think the average is about 22% pay gap for the big 4s. And when they try to explain this, they usually use words such as, we only have 8% female partners, females tend to not want to become a partner at our firm. So it's not very uplifting for a young professional female that's really highly educated to join such a firm. So it is a big issue. Also, the banking industry in the UK has been at tremendous pressure. So as you can see, it's a 56% pay gap there. And it's very difficult for usually a male chairman to go out and say that you're not discriminating when you have a 56% pay gap. So it's really about preparing your narrative and how to communicate the pay gap to media, because since you will be forced to publish this if you're more than 150 employees externally, the media will be able to look at your pay gaps compared to your peers, compared to your competitors, and they will ask questions to see whether or not you can actually answer them. So it's very important. So that's the external publishing. And then internally, since you will be forced by this legislation to basically publish gender pay gaps on same work, which is equal positions, and work of equal value or equivalent work internally, you will be asked a lot of questions, right? So you should prepare to have an efficient system. You're going to have to publish this if you're more than 250 annually, if you're more than 150 every 3 years. But you also have, to Michelle's point, actually tell your employees where they can find pay gap information. So if you're a female now and you're paid less, or you look at these statistics and you see that there's a pay gap in your position, you are most probably going to go and ask your HR, how's my pay compared to my peers for equal and equivalent? And then we're back to right to information. You actually have to share that individual's comp ratio and also tell them why they're paid what they're paid. And then if you have any pay gaps that wider than 5%, it says 2.5. So as an old presentation, it's 5% now. Used to be 2.5 in the first proposal from the commission. So what you should do is really conduct in-depth analysis now to check all grades, check all positions, and ensure that you can explain any salary differences using unbiased explanations. So, and this is all really tied to your remuneration policy. So if you say that you're a pay-for-performance company, you value competence, you value experience, for instance, those three should really be your key variables that you check pay gaps for. So you can't all of a sudden say that performance is not an issue if there were to be a claim once this directive hits. So make sure to explain all unjust pay gaps, mitigate the risk of workers' representatives forcing you to conduct joint pay assessments if you have pay gaps that's wider than 5%. Also, with the burden of proof, since this whole basically transparency directive is about protecting the individual's rights, including this writing about being compensated for discrimination, it will be increasingly important for all your employers to be able to explain any type of pay differences between males and females in equal and equivalent positions. So our recommendation is that you actually start doing in-depth pay audits, not just gender pay gap analysis, but really in-depth pay audits into all equal and equivalent positions right now, so you can actually start explaining them. And also, I mean, a lot of employers and a lot of our customers and clients see this sort of as a punishment by the European Union. They're quite upset, actually, because it's a lot of work ahead, right? However, you could see this as an opportunity. So what you can do is basically sort of get ahead of the bandwagon and start. If the Netherlands actually implements this faster than 26, you might have no you might not have an option. But if you're in a country where it actually starts commencing in 26, where you need to publish in 27, you can actually get ahead of this, and you can really start inviting workers' representatives already to make sure that they're aware of what your basically figures looks like. So what you can do is invite your workers' representatives, show them the statistics, show them the pay gaps, explain to them how you set pay, what the pay gaps exist of already now. And there's a lot less likely to actually make any claims once this transparency legislation comes through. And also, imagine if you were to be the first company in the Netherlands that would be fully transparent around pay gaps way before the legislation actually hits. So let's say that you're in 2025, starts publishing your gender pay gap in your annual reports, in your CSR reporting, et cetera, et cetera. It would be pretty cool because it would really give you an edge over the competition, right? And I think a lot of your employees would not see you as an employer that might be discriminating. You would actually be able to gain a lot of your employee value proposition that way. So share data as soon as you're comfortable with it. Try to share the data. So in summary, get started now rather than later. It is a lot of things that you will need to keep track on once this hits. Make sure that you have systems and processes in place internally to handle the Pay Transparency Directive. We see that the job architecture, organizational structure will become more increasingly important since you will be publishing data externally and also publishing pay gaps internally. You really need to have a good job architecture and org structure as a baseline. Be sure that you know and feel comfortable with the salary structure. Be prepared to sort of move from a controlled environment in terms of salary to a full transparency across all levels of the organization. So everyone will see what you're paying a director in the company if you actually advertise for one, for instance. And also understand what your internal figures look like now. It's very difficult to take action if you don't know the current status for you. And we highly recommend pay audits. I mean, Sweden has had an equal pay audit legislation for the past 25 years. Most companies here have pay gaps that's less than 5%, and they can definitely explain them because they've been doing pay audits for so long that it's not very difficult to explain if there's gaps wider than 5%, what it consists of. So important fact, try to do pay audits. Start communicating internally and possibly externally if you're comfortable with your figures. And make sure that senior management and the board of directors are fully aware of what's actually coming. They don't like the negative press that might come from the directive, and it can also come with a very hefty price tag if you have unwillingly discriminated someone with the back pay and everything. And start really engaging with workers' representatives now around pay equity, so there's basically built up trust once this directive commences, so you don't have to get sued by them, basically. So shall we move over to questions and answers?
Absolutely. Thank you very much, Magnus, for these clear recommendations. That is I think the main point that we want to make in this webinar, the three of us, that it is the best thing to do is to start now preparing, because you know it's coming. So make a head start and take the advantages of being a transparent company seems to us the wise thing to do. So we had already, the Q&A is already working. We have a few, we've had a few questions which have been answered also by Michelle.
Magnus, maybe one question that we can maybe discuss in the group. One of the questions was if a company has more locations across the EU, should every location in every member state report individually, or can you do a joint report? I don't recall reading anything about this in the directive, but perhaps you have more insight on this?
Yeah, what you need to do is you will be forced, since it's national legislation, so every legal entity with more than 150 employees per country, so to speak, will need to report on their gender pay gap. But then most of our customers that have that type of situation actually aggregate the pay gap as well. So they show sort of a weighted pay gap for all of EU or the EU member states, and then they do separate gender pay gap reporting as well. And some of them are really complex. I mean, a lot of this becomes really difficult. If you're one of those companies that have set up a lot of subsidiaries across different countries. So our worst one is probably like 280 subsidiaries across the EU in 14 countries. And a lot of them are bigger than 150 employees per entity, right? So they will be basically publishing pay gaps for at least 120 different companies across different countries, and then they need to aggregate this. So it's going to be a lot of reporting to do. But that's basically the way the directive works. And that's also a challenge for you as an employer, because let's say that you have a pay gap in the Netherlands of 3%, and then you have a pay gap in Germany of 12%. And the media can see this. So they're going to ask questions to the Dutch management. Are you discriminating in Germany, for instance? So it's just going to be full transparent, basically.
Thank you for that.
Sure.
Any other questions, Michelle, that you want to highlight from the Q&A?
Yeah, one of the new questions is, can employees use the information to sue the employer? Yes, I think that's a fairly straightforward one. And I think that's also the purpose of this whole directive, to give employees more access to information, also allow them to use it. So yes. Do you expect that this will also lead to pay discrimination claims on other grounds? That might be the case, yeah, because indeed you can discriminate on other grounds than a male-female. And if this forces employers to be more transparent, that could also result in other discrimination issues coming up. So yeah, I think that's definitely a possibility. Then a question, can the employer still ask how much a candidate wants to earn? In my experience, that is more common than asking how much someone earns now. I would say that that is still a possibility. I think the directive only prohibits you from asking the earlier earned salary, but I don't see any reason not to ask how much they would want to earn.
Any thoughts on that, Magnus?
No, I agree, and I also think with the since you will be publishing salary ranges for any open position, that will actually probably help your recruiting, because you won't get people applying that wants something completely different in terms of salary. So if you see that it's 5 to 10 to 8K, then at least you're going to be within that range as a candidate as well, hopefully.
Yeah, that will also.
There's another question here around. To me, if I can name a couple of elements that we should think about when properly justifying the pay gaps. So with the Transparency Directive, this is really going to be tied to your compensation policy. So if, Michelle, please comment on this as well, but at least the way we see this is basically what you put in your salary criteria and what you put in your compensation policy is basically what you will be allowed to actually justify the pay gaps with. So again, you can't say that you are only paying for competence and then not have sort of a competence variable when checking for the pay gaps. So it's going to be tied very much to what you say or what you communicate to employees in terms of that. So it's very individual, but I think that the most common one and the default ones that we have in our application is around experience, the work-life experience, tenure at the company, time in role,
education,
performance, competence level. So there's a bunch in there, but I mean, that's usually what most companies use to explain.
Yeah.
Thank you.
Okay, another question is, who will determine the penalties? That is up to the national legislators. So the EU directive only mentions that it should be sufficient and high enough to be felt as a punishment, but the actual numbers will ultimately be determined by all the national member states. It could either be amounts, or it could also be a percentage of your yearly revenue, because then, of course, for companies having a higher revenue, that will hurt more than just including a fixed amount of the penalty. So each member state will do that individually.
And I also think that there's a greater penalty than actually paying a fine, and that's the bad publicity that this is going to give. So if you're cautious about your employee proposition and the way talent actually reviews you, if you would eventually get fined for not having equal pay for equal work, you would probably disqualify about 80% of all female applicants. So you would basically disqualify almost 50% of the competence in the market. So regardless of fines, I personally believe that this is more a social issue almost, where you really want to make sure that you are a fair employer, or perceived as a fair employer, I should say.
Yeah, there was a back pay issue, I think a year ago or something, which was all over the newspapers in the Netherlands. So it's, yeah. Any other questions from attendees?
Yeah, one of the questions is, does this mean that we should create a compensation policy if we don't have one in writing yet? Yes.
Yes.
We'll need to have that in place, definitely.
Yeah, depending on the number of employees, a little bit, but yeah.
And there's also another question: when work is being outsourced, will the employer be obligated to share their internal pay scales? No, I mean that will be up to the employee that employs the outsourced personnel, not you as an employer. If I read the question right. Yeah,
I agree. I think there was also one practical question, which is whether we will share the deck afterwards. We will definitely do that. And I believe also the recording will be shared.
Yes, we will share the recording, yeah.
And I think it's also allowed to share that, right? It shouldn't stay within the group of participants to this.
No. Please feel free.
Yeah.
Okay.
As far as I'm aware.
I think we covered all the questions.
Yeah.
And it's almost time.
Yeah.
Perfect timing.
It's perfect timing. So if there are no more questions and no hand showing for questions, then I would very much like to thank all the attendees for attending this webinar, and very much also the panelists Michelle and Magnus for enlightening us on this subject. Feel free to contact us, of course, about gender equal pay, and we'll hope to see you in the next webinar.
Great. Thank you very much, guys. Have a good day. Thank you. Bye-bye.
Bye-bye.
Thank you. Bye-bye. Bye-bye.
Bye.